Hey everyone! You know that feeling when you shake hands on a deal or sign on the dotted line? That solid sense of certainty? Well, what if I told you that some agreements are basically legal ghosts? They're dead on arrival, no matter how official they might seem. Today, we're jumping into the really strange world of void agreements.
It's a weird thought, right? You do everything by the book, you sign the papers, but legally, that deal is a total non-starter. It has zero force, no consequences, it never really existed. That, my friends, is a void agreement, and we're about to show you exactly how to spot one.
So, here's our game plan for today. First, we'll figure out what makes an agreement dead on arrival. Then, we're going to look at deals that try to limit your personal and professional freedoms, and, importantly, the exceptions to those rules. After that, we'll get into agreements that are way too vague or try to block you from getting justice. Then we'll tackle the whole issue with bets, and we'll wrap it all up with promises that are, well, just plain impossible to keep. You ready? Let's do this.
Okay, let's dive right in. Before we get to some of the wilder examples, we really have to get this core idea down. What is it that actually makes an agreement void from the very beginning?
Okay, see that Latin phrase there? Ab initio. It means from the beginning. And this is absolutely crucial. We're not talking about a perfectly good contract that somehow went sour. No, a void agreement was never valid. From the second it was made, it was a legal nothing. That means no rights, no obligations for anybody.
So the law is actually super specific about the kinds of deals that are automatically off the table. And this list here, it covers a lot of ground. We're talking about everything from trying to control your personal life, like who you can marry, to limiting your career, making promises that are too vague, or even just making a simple bet. We're going to break down each and every one of these. All right, first up is a really big one, personal freedom. You know, our whole legal system is built on protecting individual liberty, but sometimes people try to use contracts to chip away at those freedoms. And as you're about to see, the law really doesn't like that. So here's the bottom line. The law is incredibly protective of your right to marry who you want and your right to earn a living. So if someone makes a deal to pay you not to get married, or an agreement that tries to shut down your business forever, that agreement is totally void. It's considered against public policy to restrict these really fundamental rights.
But, like with most things in the law, it's not always so black and white. That rule against restraining trade, it's not absolute. In the business world, some restrictions are not just reasonable, they're actually necessary to make sure everyone's dealing fairly. So, let's look at when a restraint is actually okay. This shows us the two main ways the law makes these exceptions. And believe me, they aren't just random. First, you've got statutory provisions. These are rules written directly into the law books. And second, you have judicial interpretations, which are exceptions that courts have created over time based on real-world cases. And these make a ton of sense when you stop and think about it. I mean, if you buy a bakery, you're not just buying the ovens, you're buying its reputation, its goodwill. It would be completely unfair if the person you bought it from could just open a new bakery right next door and steal all their old customers back. And it's the same with partnerships. It's only reasonable for partners to agree not to compete against their own business. But, and this is a huge but, even when an exception is allowed, the restriction has to be reasonable. This old case is the perfect example. A guy who sold imitation jewelry in London was restricted from selling real jewelry anywhere in England or a bunch of other countries. The court basically said, whoa, nope, that's way too much. Any restriction has to be fair in how long it lasts and the geographical area it covers. You can't just stop someone from working in their field forever, everywhere on the planet. The courts have also recognized other common-sense situations. Take a franchise agreement. Of course, it can require the owner not to sell competing products. That's just protecting the brand. And it's totally normal for your employment contract to say you can't moonlight for a direct competitor while you're still working there. That's just loyalty. But a clause that tries to stop you from working for any competitor for, say, 5 years after you leave, yeah, that's probably going to be void.
All right, let's switch gears a bit. These next two types of void agreements are all about clarity and fairness. A deal can fail either because it's so vague nobody can figure out what it actually means, or because it tries to unfairly block someone from using the legal system. This is just a basic, fundamental rule of contracts. Think about it. For a court to enforce a deal, it has to know what the two sides actually agreed to do. If the terms are just hopelessly confusing and there's no way to clear them up, the law basically just throws its hands up and says the whole thing is void. This is the classic textbook example. A agrees to sell B 100 tons of oil. Okay, is that crude oil, olive oil, motor oil? Who knows? Because the kind of oil isn't specified, you can't enforce the contract.
Now, if A was a dealer who only sold, say, coconut oil, maybe a court could figure it out, but as it's written, it's just way too vague.
And this one is huge. You simply cannot have a clause in a contract that says something like, if we have a fight, you're not allowed to sue me. Access to the courts is a fundamental right. Any agreement that tries to completely block that right, or even tries to shorten the legal time limit you have to file a lawsuit, is void. The law will always protect your path to the courthouse.
So now, let's talk about something that comes up all the time. Bets. We make them with our friends, maybe an office pool, but what's their actual legal status? Can you sue your buddy if he doesn't pay up on that Super Bowl bet? Well, the short answer is pretty much no. The law sees these as wagering agreements, and they are generally void.
You know, it's really interesting to compare a bet to an insurance contract, because on the surface, they both depend on some uncertain future event, right? But their whole purpose is different. A bet is just about making a profit from pure chance. But with insurance, you have what's called an insurable interest. You would suffer a real financial loss if your house burned down. The insurance contract is there to make you whole again, to compensate you for that loss, not to make you rich. And that is why one is a valid contract that serves the public good, and the other is legally unenforceable.
And here we are at our final category. And honestly, this one might be the most straightforward of all. We're talking about agreements that were just doomed from the very start because they are based on doing something that is quite literally impossible.
To put it simply, the law does not deal in magic or science fiction. If you agree to do something that is physically impossible, that agreement is void. And get this, it doesn't even matter if both of you honestly thought it was possible at the time. If it's objectively impossible, it's a legal dead end.
This example is, well, it's pretty dark, but it makes the point perfectly. Promising to bring someone back from the dead is pretty much the definition of an impossible act. There's no legal, scientific, or any other way to do it. So any contract that promises something like that is completely and totally void from the get-go. Okay, so let's tie this all together. What have we learned? A void agreement is a legal ghost. It was never really there. We've seen that the law steps in to protect our fundamental freedoms, that it demands our promises be clear, that it generally won't enforce our bets, and that it flat out rejects the impossible. These aren't just little technicalities. They're rules that ensure a basic level of fairness and common sense in the agreements we make.
And that leaves me with one last question for you. Think about that non-compete clause you may have signed, or that casual bet you made with a friend, or even just that handshake deal where the terms were a little fuzzy. After everything we've gone over today, how solid do those agreements really look now? Thanks for tuning in.